Welcome to Ekcel Academy. In today's session, we are going to deal with the drafting, pleading and appearances. It forms a part of the CS professional program. It is introduced in Group 1 as paper 2. Before going into understanding the overview of the syllabus or dealing in the subject itself, let us understand the intention of the institute to introduce this particular subject at the CS professional program. All of you are going to soon be qualified company secretaries. Once you pass the exams of CS professional program, you will qualify as a company secretary. So whether you become a company secretary in employment or company secretary in practice, both the fields require a lot of legal documentation. You have to prepare the documents for your company or your clients day in and day out. The company secretaries, being the legal and compliance officers, have to deal with legal documents. And for preparing those legal documents, certain basic concepts, principles and theories are required, which is included in this particular chapter. So the institute wants its students to be ready for the market. They want the students to have all the necessary skills that are required to start working in the professional world. With this intention, the institute has introduced this particular subject at the CS professional program. Let's understand the basis of this particular subject. This entire subject covers three aspects: drafting, pleading and appearances. Before understanding each one of this, let's take a quick example. Let's assume that you're living in a locality where opposite your house there is a school. During the peak hours, that is in the morning when people come to drop their children, and in the evening when they're going to come and pick them off from school, there is peak traffic because everybody is in a hurry. They want to finish first and take their kids and leave. So that time there is no proper traffic management by the school. At that point in time, there is a lot of nuisance that is created for the residents of the place because all the parents, auto drivers are parking their vehicles right in front of the gate where you are not able to open the gate of your house. You're not able to step out. So even you are getting late for work. So at that point in time, all the residents collectively think that let us take an action, let us take this particular issue and get a solution from the school. For that, what are you going to decide? You're going to decide that let us write a letter collectively and get the signature of all the residents that this is going to cause a nuisance for us, and the school has to give us a proper solution for traffic management and clearing the nuisance, and that letter has to be submitted to the administrators or the management of the institution. So that is what we are going to do here. What are we going to do? We are going to do drafting. What are we going to draft? We are going to draft a letter. We are going to draft a letter that itself includes drafting. Pleading, we are going to request on the basis of the facts of the nuisance. We are going to ask them to give us some kind of remedy so that there is no nuisance that is caused in the premises during the peak hours of the school. And we are going to submit that letter to the administrators or to the management of the school. This is drafting, pleading and appearances simplified. Now let us understand, as CS professional students, are you new to drafting? The answer is no, because all of you have passed the CS executive program. In the CS executive program, you have written the answers, you have drafted the answers for the questions that have been posed in the question paper. So all of you are well versed with drafting, but now what are we going to focus on? We are going to focus on the legal aspects. We are not going to focus about what are the other documents we are going to draft. We are going to focus on drafting of the legal documents and pleadings before the courts of law and appearing before the courts of law. Here general example I have given, but we are going to focus specifically on writing the legal documents, pleading before the courts, the remedies, and appearing before them for having a discussion. With this particular objective, let us see what is each one of these concepts theoretically. First, drafting. What is drafting? It is nothing but an act of what? Of preparing, of writing the legal documents, which could be either agreements, contracts, deeds or resolutions. As a company secretary, it is our duty to conduct the board meetings, general meetings, to maintain the resolutions, to draft the resolution, to get it passed at the meeting, to maintain the minutes book. So at that point in time, a lot of legal documentation is required, and you should be in a position to draft those documents. So that is drafting. Now, for being able to draft a good legal document, there are three things that we should focus on. For any good legal draft, there should be a proper nexus. Nexus is nothing but connection. You should have a connection between the law, the facts and the language that we are going to use to connect the law with the facts. Let's take an example that you want to draft a sale agreement. In that case, you know who is the buyer, you know who is the seller, you know what is the consideration that the buyer is paying the seller, which property you are going to buy and sell. All the details are available, but will you be in a position to draft the agreement of sale until and unless you don't know what the Transfer of Property Act of 1882 talks about sale? Section 54 clearly includes certain aspects of what is sale, what are the transactions, what are the responsibilities, rights and obligations of the parties. All that is required. The primary legal concept is required to be able to understand and analyze that into the facts or circumstances of the case. So wherever we are going to study the concept of drafting, whatever document we are going to draft, the first and foremost thing is analyzing the law, understanding the concept. Only if you know the law and the concept well, you will be able to implement that or analyze and include that into the facts of your case using the appropriate language that is there. So for a good legally drafted document, there should be a proper connection between law, the facts and the language that is being used for connecting the law and the facts with each other. Now, next is pleading. What is pleading? Pleading is nothing but we are humbly requesting for something or asking someone for something. A small child comes up to you and tells, please give me a chocolate. That small baby is asking for a chocolate. He is pleading for a chocolate. Now, when we are going to talk about legal perspective, what are we going to do? We are going to appear before the courts of law, tell them the facts of the case, tell them what is the problem and ask them for some kind of solution. We are requesting them for some kind of solution on the basis of the facts of the case and what are the problems that you are suffering. So, what is the actual definition of pleadings? Pleading means a written representation. In writing, you are going to submit a document to the regulatory authorities or the courts. By whom? By the litigant of the case. The person who is going to file the case, that person is going to submit a document to the court telling what are the facts, what are the problems and what is the remedy that he is claiming. Where he is going to include the facts upon which he is asking for some kind of relief. There are two parties to any case. One party, the person who files the case, who initiates the case, is called as the plaintiff. And the person against whom we are going to file a case, that person is going to be called as the respondent. The plaintiff is going to file a document which is called as a plaint, in which he is going to include what are the facts of the case, what is the problem he suffered because of which there is a necessity of filing the case, and what is the remedy that he is seeking from the court for solution for that particular problem. Now, when this particular plaintiff is filing a case, he is definitely filing against some person who is the opponent, who is the respondent. So, this particular respondent in his response has to submit a document which is called as the written statement. In this particular written statement, he is going to include his side of story, his point of view of all the facts that has been mentioned, all the problems that he is quoted, what is his point of view on that, that is going to be included, and ultimately what is the remedy that he is asking on the basis of the case that is being filed against him, that is going to be included. So, if you actually see from the legal point of view or the definition of pleading under the Civil Procedure Code, they clearly say pleading means plaint and written statement. This is the definition. Actual definition of pleading under the CPC says that pleading is a plaint and a written statement. In both plaint and written statement, we are going to mention the facts, what are the problems and what is the outcome, what is the thing that we are requesting from the courts of law is what is going to be included in pleadings. And as company secretary students, you might have to appear before the courts of authorities and you should know these basic principles of what is pleading, what are the rules of pleading, and that is why this concept of pleading has been introduced in your syllabus. Going next to actual definition that has been provided for pleadings by MOGA, they say pleadings are statements which are in writing, drawn upon and filed by each party to the case, whether you are the plaintiff or you are the respondent. Both the parties have to submit their pleadings before the court, stating the contentions, stating what they are going to tell, what facts they are going to claim before the courts of law, and giving all the details as may be necessary so that the opponent gets to know what you are going to tell, so that he can prepare his case on that basis. Until and unless you don't know what the other party is going to say, you will not have an answer for that instantly. So you should always be aware of what are the contentions of the other party, so that you can actually give a suitable reply to that particular question that has been asked. So in short, what is pleading? Pleading is nothing but mentioning the facts, mentioning the problem, and seeking for or requesting for a remedy before any judicial or quasi-judicial body. Next is appearances. What is appearances? As a company secretary, we have to represent our clients before various regulatory authorities, for example, nationally company or tribunal. So at that point in time, when we are going to appear in front of the judge, formally going to appear in front of the judge for getting your case decided for your client, that itself is called as appearance. With respect to appearance, our subject or our entire syllabus is divided into two aspects. One is with respect to basic ethics. As a representative, as a professional member, you should have certain kind of duties towards the court, duty towards your client, and duty towards your opponent. You should follow certain basic principles of ethics and morality that is included because you are going to represent. So you should know what are the ethical behaviors that you should have. In addition to that, what are the etiquettes? What is the discipline that you should maintain? How you should appear? What is your dressing sense? How you should talk before the court? All that is a part of this particular syllabus. And court craft. What is the technique that you're going to use when you're going to appear before the courts? All these points are covered under one aspect. And the second aspect is what are the various regulatory authorities before which, as a company secretary, we have a right to represent our clients. So this portion is primarily theoretical in nature. What we are going to study in pleadings and drafting will involve practical element, and this particular concept of appearances is mainly theoretical based. We don't have a lot of practical aspect in this particular part. So your subject on drafting, pleading and appearances is a combination of practical and theory, because like I said if you want to draft a good legal document, you should know the law very well. You will know the law very well only when you are focused on the theoretical knowledge that we have studied in CS Executive, whether that is Transfer of Property Act, whether that is Civil Procedure Code, whether that is Civil Criminal Procedure Code or Companies Act, about what should be the content of resolutions. So until and unless you are not thorough with your theoretical or conceptual knowledge, it is very difficult for you to draft a good legal document. So that is why whenever the students ask me whether DPA is a practical paper or a theory paper, I always say that it is a combination of theory plus practical. Why I say theory? Because until and unless you don't know the theory, you cannot implement the practical. You cannot draft a document till you don't know what is the law. So that is why it is a combination of theory plus practical, where in drafting and pleading we have a lot of practical writing and assignments to do, whereas in appearance it is purely theory based. What is the objective of the entire syllabus? We know the syllabus is divided into three concepts. One is drafting, second one is pleading, and third one is appearances. Coming to pleadings and appearances, what is the objective? They want to provide you competency. But what is the meaning of competency? It is nothing but they want you to give the ability. They want you to have the ability. They want you to have the necessary skills. They want you to have the necessary characteristics so that you can execute any kind of work, so that you can perform your functions as efficient as possible. They want you to do your work with all the characteristics and skills that are required for execution of that particular work. For pleadings and appearing before the court, there are certain skills and characteristics that are required, and they want you to have the ability to do that after studying this particular syllabus. And coming to drafting, they want to provide you practical exposure. They want to equip you with the practical aspects of drafting. They have included a lot of legal documents that you have to legally draft as a part of your syllabus. So in the question also, they are going to give you the facts of the case and ask you to draft a particular legal document. That could be draft a sale agreement, draft a rent agreement, draft a resolution, draft a pleading that you have to submit before the courts of law. Anything can be asked. So they want to actually give you practical exposure of drafting the legal documents. Could be agreements, documents, applications filed before the tribunals. So this is the overall objective of introducing this particular drafting, pleading and appearances as a part of your syllabus. Now coming to the syllabus itself, we know that the entire subject is divided into two parts. Part 1 deals with drafting and conveyancing, which is for a total of 70 marks, and part 2 consists of pleading and appearances, which is for 30 marks. Right? So we have understood what is drafting, we have understood what is pleading, we have understood what is appearances. But one word that we have not dealt with is conveyancing. What do you think is conveyancing? Conveyancing is also a part of drafting. Okay? Drafting is very wide. Conveyancing is a narrow description. Okay? Now, conveyancing also is drafting. But we are going to draft with respect to a particular specific subject matter. Drafting can be anything. But when we are talking about conveyancing, we are specifically talking about Transfer of Property Act. Let's see the definition of conveyancing. Conveyancing is an art of what? Of drafting itself. Conveyancing is also drafting, but with a specified or specific or specialization in a field of what? In those deeds and documents where the right, title or interest in any immovable or movable property is transferred from one person to another person. So wherever we are going to draft a document where by Transfer of Property Act is going to become applicable, where you are going to transfer either the right, the ownership or any kind of interest in the movable or immovable property from one person to other person, that document, through that document we are conveyancing, we are conveying something, we are giving them something through the execution of a particular document, and that is called as conveyancing. We are going to convey them the right to use the property, we are going to convey them the ownership of the property. So there is a transfer element involved, and then we say that that document, through the document we have done conveyancing. Right? So let's get to the basic of the syllabus. Part 1 consists of 8 chapters, 1, 2, 3, 4, 5, 6, 7, 8. Okay. So now out of this, the first chapter is types of documents, which is basically theoretical. General principles of drafting is theoretical, which is most important. Why? Because until and unless you don't understand the general principles of drafting, it is very difficult to go ahead with the remaining chapters. This is the basis on the basis of which the other chapters are created. So first you have to focus on general principles of drafting. Next, all the other chapters are related to actual practical knowledge. So first two chapters are theoretical based, all the remaining chapters are practical, where they are asking you to do the practical work related to conveyancing, drafting of agreement deeds and documents, drafting of commercial contracts under Indian Contract Act, drafting under Companies Act like various resolutions, opinion writing for your client, and contract management. So these are the aspects that are covered under this particular part 1. Part 2 has the remaining chapters 9 to 14, which is predominantly theory based. Only this particular chapter is practical in nature. Okay, and here certain elements, theory plus practical, where you are going to see the basic establishment of courts, the framework, how the judicial system works, quasi-judicial system works, pleadings, art of advocacy and appearance. So you have 2 chapters for appearances. This is one chapter on appearances, chapter 1, and this is the second chapter on appearances. Right? And you have these provisions. Right? So now Let's directly go into the most basic chapter on the basis of which the entire subject is based. So this chapter is the foundation for the subject. If you know this chapter well, you will be able to do all the drafting work, the practical questions quite easily. So the name of the chapter is the General Principles of Drafting. Okay, let's begin with chapter number 2, that is the General Principles of Drafting. Giving the introduction of why it is important for a company secretary student or a company executive or any corporate personnel to have the knowledge of drafting and conveyancing. Why is it important? Because as a company secretary, as a corporate executive, day in, day out, we deal with a lot of documentation. Till you don't know how to read the document, how to draft a document, or how to interpret the document, it is very difficult to execute your work. So that is why understanding the concept of drafting, pleading and appearances is very, very important. But now we are going to specifically focus only on drafting aspects. We are going to see the principles of drafting, and that is why for a person to be able to draft a legal document, certain principles are required, as he is going to day in and day out deal with those documents. That is why it is important for a corporate executive, whether it is a company secretary or anybody who is in a corporate field, they should know how to read legal documents and draft a legal document. Now, the importance can be understood from 3 points. First one is for obtaining legal consultation, for carrying out the documentation work for various departments, and for interpreting the documents. So as a corporate executive, you are a company secretary, you are an expert in corporate laws, but you might be in a situation where you yourself are the legal and compliance officer, you are heading the legal department as well as the secretarial department for a company. At that point in time, if there arises a matter of taxation, which you are not maybe well versed with, you know the basic aspects of taxation, you have studied under your syllabus, maybe that practical exposure we don't have with respect to the taxation aspects. At that point in time, as a company secretary, you might also want to seek advice or take opinion from experts in the field of taxation. So when you are going to ask them doubts, or when they are going to give you the reply to the doubt, you should be in a position to analyze that, should be able to understand what that particular person has written, what advice he is given. For that purpose, whenever we are going to obtain legal consultation, for that also basic drafting skills are required. Carrying out documentation departmentally. As a corporate executive, as a company secretary, all the documentation work is going to come to your table if it is legal related. So you have to be well versed with the principles of drafting. And lastly, for interpretation of documents, you will receive n number of notices, documents from various authorities as a company secretary, as a compliance officer. So you should be able in a position to interpret those documents. You are going to be the legal and compliance officer, head of the legal department as well. So you will be responsible for n number of contracts that the company is going to be executing with its customers, with its suppliers, with its regulatory authorities, with the stock exchange if it is a listed company, listing agreement, with the underwriters or intermediaries if it is going to become listed company. So n number of contracts are employee contracts. So n number of contracts are required to be executed by a company, and those all contracts or agreements are going to be legal documents. And at that point in time, interpretation plays a very important role about what clauses should be included, what clauses should not be included. For that reason, the basic principles of drafting should be well versed by the corporate executives. Next, so the same thing that I have explained to you is included in this particular chapter. 3 points that I've told you for obtaining legal consultation. Why is it important? When we want to seek a legal expert's advice with respect to the matter to be incorporated in the documents, decide upon the coverage, and having laying down the rights and obligations of the parties therein. For this thing, we might need the legal advice, and that point in time it will become helpful. Now, by taking the legal opinion or suggestions or consultation, how can it benefit? Better communication. How? If you know the basic provisions, you might not be an expert, you know the basic aspects of drafting, you know the basic aspect of taxation, but you don't know how to execute a particular clause with respect to taxation. Okay, in that case, if you have the basic knowledge, if you have the basic conceptual knowledge of both drafting as well as the concept that which is under question, then you will be able to have a better communication with the expert. If you have no knowledge at all, what communication are you going to do with that expert? Only if you know something, you will be able to communicate with that person and get the necessary output. Extraction for more information. If you know nothing, whatever the expert is saying, you're just going to write it down and come back. But if you yourself are well-versed, not well-versed, even if you have little knowledge about that particular topic, you can initiate a conversation. You can extract as much as information as you want with respect to that particular topic from an expert. If you're a person who knows nothing, you'll simply go there. Whatever he says, you're going to note it down and come back. But if you have even slightest of knowledge about it, you can question and get multiple answers from that particular expert. Arriving on workable solution. What is the solution for that particular problem for which we are seeking expert advice, and facilitate settlement of the draft document. So on the basis of this, we can execute the document. Carrying out the work departmentally, all of us know for any company, the company is divided into departments, and each one of the department will have a lot of documentation work to do. For that documentation, at least the basic principles of drafting are required. For interpretation of documents, very, very important is using the right language in the document. For what? The language that we are going to use in the document should be in such a way that whatever we have, with what intention we have included that particular clause, in the same intention, it should be conveyed to the person who is reading the document. You have written from one point of view. The reader, when he reads that statement, should also understand in the same point of view. So that is the interpretation, because whenever we are going to see, you have already studied JIGL. In your executive program, we have specific rules for interpretation. So if there is any dispute about understanding a particular sentence, one particular sentence can be understood by multiple ways if there is no clarity in that particular statement. So for that, whenever you are going to draft any document, you should keep the basic principles in mind, so that whatever you're drafting should be clear cut. There should be no scope for further interpretation as such. What you are intending and writing, the same thing should also be communicated to the person who is reading that particular document. That is why clarity and precision is very important while you are drafting the legal documents. Going to what is drafting and what is conveyancing. Drafting, all of us know, it is an act of preparing the legal documents like agreement, contract, deeds. This is what is drafting that we have already covered. Now, going to the actual definition. It is a synthesis of law, facts put in the language form. It is nothing but a combination. It is a combination of law and facts which are put together by using an appropriate language. That is called as drafting. This has been given by Stanley in his book. Next. Drafting, okay. Now, entire syllabus is going to be focused on legal drafting. What is legal drafting? It is nothing but crystallization and expression in definitive form of certain legal rights, privileges, functions, duties and status. Whether it is a sale agreement, what is the right of the seller? What is the right of the buyer? What is the obligation of the seller? What is the obligation of the buyer? All these points have to be included in drafting. So whenever legal documentation is there, we are going to specifically focus on what are the rights, what are the duties, what are the privileges, what are the obligations. Because out of legal rights itself, all this is going to arise, and each one of these points should be addressed in your legal document. So drafting is the development and preparation of legal instruments like constitutions, statutes, regulations, ordinance, contracts, wills, conveyance, etc. So even the parliament is going to write the law, which is a bill, and that is going to be passed as an enactment. That itself is also called as legal drafting, because they are writing what? Writing the enactment itself. They are writing the statute itself. That is also called as legal drafting. Now, for being able to draft the documents efficiently and effectively, there are certain prerequisite skills that are required. Important skills. Without these skills, you will not be able to execute a good legal document. What is it? Like I already told you, three things are primary. Knowledge of fact, knowledge of law. You should have the knowledge of law, only then you will be applying the law into the facts of the case. If you are not clear with the facts itself, how are you going to connect that with the law? Or if you don't know the law, how are you going to connect that with the facts? So having the full-fledged knowledge about the facts of your case without any kind of confusion, and also the provisions of law, with this basic foundation itself, you will start the process of drafting. So those are the two things that are required if you want to start the drafting process. Next, ability to arrange the facts in a systematic and organized and logical manner. You cannot have an haphazard document. There should be a systematic and logic, point by point clauses in your legal documents. So suppose let's take the same thing. I'm dealing with example of sale agreement. In the sale agreement, if you're going to say that what are the obligations of the buyer, obligations of the seller, rights of the buyer, rights of the seller, suddenly in between obligations I cannot start writing the rights. There should be a proper logical sense of why we are including a particular clause at one particular point, right? So whatever you're doing, it should have a systematic and logic manner of including into the legal document, and ability to draft the document in a way that it is self-contained and self-explanatory. Your document should be so clear that after reading the document, the person should be able to analyze the entire facts of the case without any kind of confusion. The document should be self-explanatory. Next, you should have the ability to draft a document without any patent and latent defects. What does this mean? Patent means any defect that is on the face. On the face of your office, you know that there is some kind of defect, there is something that is wrong. Latent means it is not identifiable, but there is a kind of defect. Any kind of defect, whether it is patent or latent, you should be able to do it without any kind of defect, whether it is on the faces of it or you cannot identify there is a mistake. But in your document, there should be no mistake, there should be no error. There should be an ability to give correct presentation of legal status, privileges, rights, etc. that are there. And you should have the ability to convey the intention. Most important thing for any writing or any documentation is, with the intention that you have written, has the reader also understood it in the same sense or not? If it is same, that means your document is a very well drafted document. So if you have these necessary skills, you will be able to draft the legal documents in a very, very efficient and good way. The entire process of drafting is covered into two steps. First step is conceptual, where we are going to think. Suddenly I tell you, write an answer on characteristics of a company. First you'll think how you're going to structure your answer. Then you're going to start writing, that is verbal writing, putting it into words. Verbal means not necessarily oral, it means putting into words. Putting the words into writing. So documentation or the entire drafting procedure is divided into two steps, where first one, we are going to brainstorm. We are going to identify how we are going to structure the answer, what are the things that we have to include, and once we have created a structure in our mind, then we are going to put it into paper, that is verbal. Now, first let's think about conceptual. When you're thinking, what are the things that you should keep in mind? This step involves thinking, which can be called as brainstorming. Suddenly, if a topic is given, a question is given, you are asked to draft a legal document, the basic thinking work is required to be done, and that is called as brainstorming, in which you should understand following things. The reason behind drafting a document. Why am I preparing this legal document? Why am I required to prepare this legal document? What is going to be the outcome once I finish this legal documentation or legal work, right? So for that, the primary reason of conceptual or thinking, your thinking process should start with, why should I draft this particular document? What is the reason behind drafting that particular document? Next, what are the laws that are going to be applicable? What are the facts of the case? And then on the basis of this, what is going to be the content that you have to include in drafting. This is your stepwise thinking. First, you should think why I'm doing it. Then you know why you're doing it. Then you're going to see what are the laws that are applicable for that situation. Once you know what are the laws, you will see what are the facts. You're going to connect the law with the facts and then start writing the content, structuring the content in your mind. Once your thinking procedure is over, you have identified the purpose, the law and the facts, then you're going to prepare yourself to actually start the verbal work, that is nothing but putting your thoughts into writing, putting your thoughts into words. This step involves putting the thoughts from the first step, the brainstorming you have done, you have thought a lot of things, putting that into writing itself is called as verbal or composing. It involves various steps, that is first draft document, editing the document and finally having a full proof document. First we are going to make the draft, then we are going to read it again, we are going to find errors, we are going to make changes, we are going to make alteration. Multiple times we are going to do this, and once you are satisfied with the final set of document, that document is going to be called as the final document, which is done. Necessary proofreading has been done. There is no grammatical error, there is no spelling error, there is no any error with respect to concept or facts of the case. That is putting your thoughts into writing. Next. So the entire summary of drafting is the ability to collect, consolidate and coordinate the facts and the law in a document. So it is nothing but combining the facts and the law with the use of a language into a set of document is called as drafting. It involves a lot of thinking process. You have to think before starting a drafting procedure. So it is thinking process, and after you have done the brainstorming and the thinking work, then you have to reduce that into writing by using the appropriate legal language, and all your legal documents are always subjected to legal or judicial interpretation. Today we have entered into an agreement to sell. Both the parties are in good terms and conditions, there is no problem. But at a point in time, if a dispute arises, you are going to file a case. So then that document itself, the legal document that we have drafted, the agreement for sale, that itself is going to be placed before the court for interpretation. What they are going to interpret, what is written in the agreement. So for that point in time, with what intention the parties have created, the same intention should be also understood while reading, because it is always open to interpretations by the courts and judicial authorities. So your drafting should be so precise that whatever you are intending, the same should be communicated to the reader as well, because in this case the reading is going to be done by the judges and they are going to give a final judgment on the basis of their decision. So for that reason, whatever intention is there of the writer, the same thing should also be communicated to the reader, and if these things are done, it is called as a good process of drafting. Next, let's go to the second concept, that is conveyancing. What is conveyancing? Like I told you, we are going to convey something, we are going to transfer something, we are going to transfer the right, interest, okay, related to a movable or immovable property from one person to other person. Suppose there is a person Mr. A and Mr. person B. Mr. B is the buyer, Mr. A is the seller. So he is going to sell his house, he is going to buy the house, right? So the agreement that is going to be entered between them is called a agreement, that is agreement for sale. Now this agreement for sale itself is not conveyancing, because in the agreement what we are saying that on a future date this particular person is going to sell and that particular person is going to buy. What is an agreement? A promise of a future execution. So an agreement for sale is not conveyancing. If you want to do conveyancing, you have to execute a sale deed, where actually we are going to transfer the interest or the right or the ownership of the property from one person to another person. So it is very important to understand that in conveyancing, it is an art of drafting only those kinds of deeds and documents where we are going to transfer any interest in land, whether movable or immovable, from one person to other person. So what is conveyancing? When we are transferring the right in a movable or immovable property from one person to other person through a document, that process is called as conveyancing, where we are going to convey the right to some other person. Now, there is no definition for conveyance or conveyancing given under any legal provisions, but the word convey has been introduced or used in two legislations. One is the Indian Stamp Act and one is the Transfer of Property Act. So by the use of it, we should analyze or interpret what is the meaning of conveyance. So according to the Indian Stamp Act, Section 2, Clause 10, it says that it includes, they say, conveyance includes conveyance of a sale and every instrument by which property, whether movable or immovable, is transferred inter vires, that is nothing but between living persons. Wherever we are going to transfer whether the immovable property or a movable property from one person and another, both person being living persons, and which is not otherwise provided under the schedule. Right? So it mainly focuses on 3 points. It says that it should be an instrument or it should be a document in writing through which we are going to transfer a property or the interest in the property or a right in that particular property. The property can be both movable and immovable, and example is sale deed, transfer of lease, release deed, settlement deed. All this, there is some kind of conveyance. In sale, we are going to transfer the ownership. In rent or in lease, we are going to only give them the right to use the property for a specified period of time, right? So that is where we are conveying some kind of right or interest in a movable or immovable property. The document through which we are going to do that work is called as conveyancing. Under the Transfer of Property Act, like I told you, there is no definition given to the word convey. We only have to interpret it from the other provisions. Okay, Section 5 of Transfer of Property Act says transfer of property means an act by which living people, always transfer it between two people, that is both should be living. If one person is also dead, then it becomes inheritance of the legal heirs. So if you want to apply Transfer of Property Act, both the people should be living persons and they are going to convey. The word conveyance comes from here, where it is an act by which living people are going to convey, are going to transfer the property in present or in future to one or more people who are also living, or to himself and one more other living person. So we are not going to see what is transfer of property. We should understand that whenever there is going to be a transfer of interest or ownership of a particular property, rights in a particular property, that itself is going to be called as conveyance. There is no definition as such. We should only understand by the legal implications. So for example, the deed of transfer is a conveyance deed. The deed of sale is a conveyance deed, right? Which could be for movable or immovable property subject to the DPA Act, and it could be sale deed, gift deed, lease deed, exchange deed or will. From all of these, we are going to transfer some kind of interest or some kind of property from one person to other person, and whichever document is keeping those terms and condition of transfer, that document, that process is called as conveyancing. Okay, so what is the summary for conveyancing? It is nothing but an act of drafting itself, but drafting specific documents relating to transfer of interest or ownership in a property, whether it is movable or immovable, keeping in mind the applicable provisions of law. Now, we should understand what is the difference between drafting and conveyancing. Now, by the discussion so far, you will already be able to understand that drafting is very generic. The term drafting is generic. Any kind of legal documentation will come under the ambit of drafting, but conveyancing is very, very specific, because it is related only to those documents where there is any kind of transfer of any right or interest or ownership in any movable or immovable property. So only the documents related to transfer in a property is called as conveyancing, but any documentation of a legal document is called as drafting. So what can you imply? That conveyancing is also a part of drafting. Next, what is the scope? Like I told you, conveyancing is a part of drafting. The definition of drafting is very broad. Drafting is very, very broad than conveyancing, whereas the definition of conveyancing is very narrow because it is limited to TP Act. It is limited to covering only those aspects coming under the provisions of the Transfer of Property Act, but here it is very broad. It is unlimited. Any kind of work, any legal document will come under the ambit of drafting. Next, drafting may cover all types of documents. Like I told you, it is very broad. It is unlimited. The ambit, the kind of documents that can be brought under drafting are unlimited. So it is all kind of documents can be brought into existence under the concept of drafting. But here it involves only those documents which are going to transfer the property. This is the coverage. Governing statutes for drafting, since n number of documents are there, you will also have to comply with the Companies Act for the purpose of drafting, let's say the resolutions or the minutes of a meeting, etc. You have to comply with the Indian Contract Act in case you are going to draft an agreement for sale or agreement for rent. You have to comply with, let's say, the CPC in case you have to draft the pleadings to be submitted before the regulatory courts. So for drafting, we do not have one set of regulation. All the regulations that are generally applicable, depending upon what document you are drafting, that law will become applicable. So based on which document we are going to do, for that document, what is the law prevailing, that law will become applicable. So we do not have a set of list of laws that are applicable for drafting. On the other hand, for conveyancing, you know specifically we have Transfer of Property Act that is applicable, and whenever we are going to transfer a property, it is subjected to stamp duty, and that is why the Indian Stamp Act will also become applicable. Next, what is the process? Drafting is merely only confined to preparing the documentation. What is drafting? We know it is two processes, thinking and writing. This is the process of documentation, that is the process of drafting, and once you draft it, the drafting work is over. But that is not the case for conveyancing. The process of conveyancing is comparatively longer than drafting because we have to ensure that that actual transfer has been executed. So we will also take into consideration the entire complete process, which includes the finalization as well as the execution of the document. The process of conveyancing is going to continue till actually the ownership is not transferred from one person to the other person. In drafting, only you're thinking and putting it on documentation. Enough, that the process is over. For example, we are drafting a resolution. What is the role? You just have to prepare that particular resolution, draft, and give that to the regulatory, whoever is the company secretary, your superior, or before the board members, you can place it. But ultimately, what is going to happen, whether it is going to be passed, it is not going to be passed, it is going to be executed, not going to be executed, that is not a process of drafting. You have to prepare a resolution, you have prepared it, you have thought about it, you have written it and given it to the authorities, that's all. Whether it is passed or not, that is subjected to the general meeting approval or board meeting approval. So drafting is only thinking and putting into writing. But in conveyancing, we should stay till the entire work is not executed. So it is a longer process when compared to drafting. Next, examples: patent assignment deed, partnership deed, notice of meetings, sale deed, mortgage deed, gift of deed. These are examples. To be very specific, you can also consider that agreement to sell is drafting, but sale deed is conveyance. Why? Because in agreement to sell, today, at the right moment, we are not going to transfer the property or we are not going to transfer any interest. We are only going to promise that in future we are going to execute this particular sale between the buyer and seller. So it is only an agreement. Today you are not transferring, but when you are going to sign the sale deed, that is the document through which actual transfer takes place. So the agreement to sell is drafted, whereas the sale deed is a conveyance document. Next, coming to the difference between Conveyance and contract. Like I told you, for agreement for sale or contract of sale is not the same as sale deed. There is a difference between a mere contract and conveyance. So we have to identify the difference between conveyance as well as between contract. Let us see the status. Conveyance is a passes on the title of the property to another person. Here there is an element of transfer, but in contract the contract remains to be performed in future and specific performance can be sought. Here the actual work is being executed. In contract we are promising the execution. We are not doing it right away. We are saying that on a future date we are going to do, and on the future date if a person is not executing the contract, you have a right for filing a case for specific performance and creating an obligation that he has to comply with the contract that he has entered into. So with respect to the status, conveyance is where actually today we are executing the transfer, whereas in contract we are just merely creating a promise and saying that on a future date we are going to execute that particular object or whatever is there mentioned in the contract. Coming to the scope. What is the scope of conveyancing? It does not create a right of any action, but at the same time it alters the ownership of the existing right. With respect to any kind of movable, immovable property, there is a change in the right of the people who are going to use that particular property, whereas in contract the rights are created on execution of a contract, that is right to sue for specific performance. You have a right to sue the parties if they are not fulfilling their obligations as mentioned in the contract. So you have a right that is created under the right to contract. Next, governing statutes. For conveyance, we have the Transfer of Property Act. Already we have seen under the governing statutes for drafting and conveyance. And for contract, we have the Indian Contract Act that is specifically provided. So these are the provisions that we are going to see with respect to conveyancing and drafting. Next point is, when is the transaction complete? We saw with respect to drafting, once you have thought about it, you have put it onto the paper, you have submitted it, the process of drafting is over. But conveyancing was larger, where you also had to focus on the execution of that particular transfer. What about contracts and conveyancing? We already know conveyancing, it is where actually once the document transferring the immutable property has been registered as required by law, only then it is going to be complete. You have paid the necessary stamp duty. If you are selling a property, the registration on the sub-registrar's office is completed. After all the legal formalities are completed, after the final document has been registered with the regulatory authorities, only then we say that the procedure of conveyancing has been completed. But what about contract? A mere contract to mortgage sale would not amount to actual transfer, because here we are only planning, we are only saying in future we are going to do it. Right at the moment we are not going to do. So here it is not going to amount to actual transfer, but merely entering into an agreement itself is sufficient. You do not have to focus about execution work when you are entering into a contract, but it is an obligation to execute it on a future date as mentioned in the contract. Next, there are certain cases, certain examples where both conveyancing and contract will be similar. Like for example, the lease. The ownership is going to remain with the owner. He is only going to transfer his right to use that property for a specific duration of time. Right? So in that case, there are certain cases where the transaction may partake both contract as well as conveyance. So those are the general basic concept of what is drafting, what is the process of drafting, what is the summary, what is conveyancing, what is the difference between drafting and conveyancing, what is the difference between conveyancing and contracts. Now let's go to the actual gist. The most important things or the principles that you should remember for being successfully understanding the remaining chapters of this entire subject. First and foremost, the basic principle is ascertaining the name, description and address of the parties to an instrument. Whenever you are going to do a legal documentation work, you should be very specific about the name, address and the description of the property that you are going to talk about. For example, I say, I, Swathi Sharma, promise to pay 10,000 rupees. Now, there are n number of Swathi Sharmas available in this entire country. If you Google, you will get so many. right? So now to be specific with Swathi Sharma, whenever we are writing the name of a party, what are we going to write? I, Swathi Sharma, daughter of so and so, aged so and so, I am residing at so and so place. If so much specific details are there, only one Swathi Sharma is residing at this place. Only one Swathi Sharma has a father's name which is so and so, or a mother's name which is so and so. So when you are specifically putting down the details so that you can identify who is the party. So whenever we are going to write the name, proper description should be given that who is the person, how basic relationship, generally father-daughter or mother-daughter relationship, what is the age and what is the residing address where that particular person is residing. This particular person can only be one person. So you will be able to identify who is this particular person. There is no going to be any kind of ambiguity on identifying who is Swathi Sharma. Coming to the address, proper full address along with the PIN details should be given when you are giving the residential address. Over and above this, for example, let's take a situation where we are going to sell a particular property. We are going to enter in an agreement for the purpose of sale. In that case, we know that we have to sell an immovable property. Let's assume we are going to sell a house. Now, if you say in the agreement that Mr. A has sold a house to Mr. B, which is situated in Bangalore, is that sufficient? The answer is no, because in Bangalore there are crores of properties situated. Which property in Bangalore? You have to clearly describe the property. Whenever we write the description of the property, we have to clearly tell what is the address, the door number or property number wherever it is situated, what is situated to the north, what is situated to the west, east, south. If your property is here, what is on this side, 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 everything should be clearly given, and that is how we are going to identify a particular property along with the measurement. Whenever you are going to describe a particular property, the measurement of the property is also to be included in the description of the property. So this is the first rule of drafting. Whenever you are describing a person, whenever you are going to describe a property, the description should be very, very accurate. The description should be complete. There should be no scope of ambiguity or confusion about who is this person or which is this property. All those kinds of confusion cannot arise. So you should be very clear while you are describing the parties or the properties in any kind of instrument. Second, obtain all necessary facts and information which are to be incorporated in the document. Like I told you, if you want to draft a good legal document, two things are very important. That is the facts and the law. If you don't know even one of them, your document is not going to be 100% accurate. So if you want to draft a legal document, the first and foremost thing that you should get access to is the facts of the case, and then analyze what are the laws that are applicable to that particular situation, and then start drafting your legal document. Next, list down the applicable laws, rules and orders and directions. So on the basis of the facts that you have obtained, you are going to identify what are laws are going to become applicable in that particular situation. What are the things that you should be taken into consideration? Has the government issued any guidelines, or has the regulatory authority issued any notification or orders with respect to that particular provision that is in question? So you should be able to identify and list down all the laws that are applicable to that particular situation and then include them in the drafting procedure. Next, draft the document in a way which is clearly conveying the intention of the party. This is to give effect that it is important that the draftman first forms a clear idea of what his intentions are. Like I told you, all the legal documents are subjected to judicial interpretation if a dispute arises. So whenever you are going to create a legal document, the most important thing that the draft person should keep in mind is what he is thinking after reading that statement. Is the same thing being conveyed or not? If it is going to be conveyed, well and good. If not, there is a need for some kind of clarity. So before doing the documentation work, the draft person himself should understand what is his intention. What is the outcome that he wants to achieve after this particular legal document has been executed. So that basic intention is one thing that you should have clarity about when you are drafting your legal document. Next general principle with respect to drafting is that you should use technical and concise language. When you can communicate a sentence in 5 words, why will you use 10 words to communicate the same sentence? So use shorter sentences, use concise words, use technical words for the purpose of drafting the legal documents. When I say technical words, that does not mean complicated words. There is a difference between technical word, complicated word or unfamiliar words. You should use the words that are going to be understood by the people who are going to read the document, but it should be in concise form and technical language. It should not be something that is not understood by any person who is going to read it. It should be understandable by a layman also. That kind of language should be used in the documentation work. Next, compliance with requirement of law and legal provisions. Whatever document we are going to be executing, that document should be legally valid. Okay, for that, basically, generally, if you see the contract, let's say we are going to enter into a contract and the agreement is, what is the agreement between Mr. A and Mr. B? Both of them are friends and both of them have decided that a particular person has gone to an ATM. He's gone to an ATM and one day we are going to, whoever is going to walk out of the ATM with the briefcase, we are going to rob that particular person. Whatever comes outside the suitcase, we are going to split that between us 50-50 ratio. This is an agreement, they have put it into writing also. But is it valid? No, because legally itself the basis is not there. It is an invalid contract. You cannot have an illegal objective for your contract. So that is what they are saying here is you should be in compliance with the law and legal provisions. You cannot merely execute or enter into any agreement. There should be a foundation of law for every document that you are going to prepare. You cannot make any agreements or a contract which is prohibitory or against the provisions of law. Very important is the validity of the document. Here you have entered into an agreement, but the agreement's validity itself is not there because it is in the contract itself is not permitted under Indian Contract Act or even other provisions of law, because you cannot rob. Robbing itself is a crime. So splitting the proceeds out of a crime does not validate the contract. So we have to first focus upon the validity of the document. What document we are going to prepare, how valid is it, and under what provisions of law it is valid. All those basic clarity should be obtained before starting any kind of documentation work. Next, knowledge of law of the land, that is your Constitution of India, and special enactments that are applicable to specific situations, which should ensure that you are not violating any provisions of law. Let's take an example. Constitution, obviously, whenever you are entering into an agreement legal document, you should keep it to mind that the law of the country should not be violated. Basically, fundamental rights should be kept in mind. Over and above that, in certain cases, special enactments are applicable. Let's assume that a company is going to enter into a contract or an agreement with the bank. What is it? It is the loan agreement. Loan agreement is valid? Yes. You can execute a loan agreement. There is a provision of taking loan and executing it between the bank and a company. But the question comes is, are we only going to see the provisions of Indian Contract Act, or we also have to see the provisions of the Companies Act? Under the Companies Act, first we should see whether the company is permitted to take the loan or not. If it is permitted, then we should see what is the limit for which it is permitted, for which we have to see special enactments. That is, first we should see the Companies Act. If in Companies Act taking loan is allowed, then we have to see the Memorandum of Association, Articles of Association of the company to identify whether that particular company is permitted under their provisions to take loan or not. So we cannot say that if a particular enactment is applicable, only that we have to see. In addition to that, there are other restrictive elements that you have to focus on. With respect to a company, they have to comply with the Companies Act. In addition to, they should do only those activities which are permitted under the memorandum and articles. Anything beyond that you cannot do. So when you are making a contract for agreement or loan, if the company says that they have maximum power to take a loan up to 2 crore rupees, you cannot create a legal document whereby you are taking a loan for 2.5 crores. the validity of the document is correct, means what you're drafting is correct, but for the facts of that situation, it is not appropriate, because according to the facts, this particular company is not permitted to borrow the loans over and above 2 crore rupees, but you have executed a loan agreement for 2.5 crore rupees. That means you have violated the provisions of articles of association of a particular company. So you should not only focus on the basic enabling provision, but also other special agreements or other special enactments that are applicable, other provisions, bylaws or rules that are applicable. All of them should be taken into consideration while we are drafting a legal documentation. Next, compliance with the format. Very, very, very important. When we are going to draft a resolution, we have a specific format. When we are going to draft an agreement, we have a specific format. When we are going to draft pleadings under CPC, we have a specific format. When we are going to write letters, that has a specific format, right? For when we are drafting the memorandum of association, articles of association, there are fixed formats that are provided under the law itself. So whenever you are drafting one of those documents for which the format has already been specified under any enactment, or there is a set protocol of doing it, you should comply with that protocol. You should follow the form, you should follow the schedule, or you should follow that particular format which is provided to you. You should only fill in the details as may be required using appropriate language, facts and the situation of law. Apart from that, you cannot change the alter or structure of the document itself, because the format has already been specifically provided to you under the rules or under the enactment. Next, statements of negative should be avoided. As far as possible, positive statements should be used. Next, order of draft order should be logical and systematic. One after one. If you are going to do point 1, point 3, point 4, point 5, there is a logic of this number. You cannot write say 2, 5, 1, 3, 4 like this. There is no logical sequence to this number. So similarly, whenever any points are coming into your mind, they should be systematically arranged. They should be systematically drafted, right? That is what they are trying to tell here. There should be a connection between one point and the other point. The legal language that we are going to use should be precise and accurate. The wordings that you are going to be using should be conveying the intention, and for that proper language should be used. The documents should be supported by annexures, enclosures, schedules wherever required. Let's take the same example of the agreement to sell. Right? I told you where Mr. A and Mr. B have executed into an agreement for selling, where they are going to transfer the house. Okay, the house is going to be transferred. In that particular case, what are they saying? They are saying Mr. A is transferring this house to Mr. B. Then I told you, whenever we are going to describe a property, full description should be given, that the property is situated here, north, west, east, south, what are the properties we should tell, and we should give a full cut description about what is the measurement of the property. Now, whenever you are going to describe that particular property, in the agreement itself, every time you cannot give full details of the property. If you keep writing, that itself is going to make the document lengthy. Because we say we should properly describe the property, we cannot say anything else, we should give proper description. If you keep on describing the property at every place or every clause that is going to be there, that is going to only make your agreement longer. So what we say, what we write, we say that we are going to talk about, or we are going to sell the property as mentioned under the schedule. We are going to mention in an agreement to sale that Mr. A is going to sell the property as mentioned under the schedule. One single sentence is explaining everything, and if you want to see which property is going to be sold, you swap the pages, go to the last and see under the schedule, they would have given the description to the property. So wherever required under whichever document, you should give additional supplements, annexures, schedules as may be required for supporting your document. For an example, the same thing, let's say in this particular agreement, agreement for sale, they have mentioned a line that Mr. A is going to sell the property as mentioned under the schedule to Mr. B, and schedule itself is missing from the agreement. How are we going to identify which property is going to be sold? So wherever you have mentioned that there is a schedule or an annexure to a document, you should add that schedule without missing it. These are the principles that you should follow while drafting a legal document. Next, the draft must be readily intelligible by a layman. If a person who does not know anything about the law, if he is reading that particular document, he should be able to understand what is in that particular document. That is the way in which you should draft the legal document. Okay, so these are the basic general principles that we should follow while drafting the legal documents. But are the only principles sufficient? No. In addition to the basic principles that we have covered to now, we have certain additional rules that we have to focus on. In that, we are going to cover these aspects. We are going to cover the 5 rules of drafting, the procedure of drafting, that is how we have to, the rules for drafting, the procedure of drafting, how we have to sketch it, how should we make the skeleton draft and then do the self-appraisal, how we should focus on certain special aspects, certain documents, and what is the expert opinion which is required to be taken with respect to drafting of documents. One by one, let us focus on each one of these points. First point we are going to focus on are the 5 rules of drafting. Okay. He says, anyone who wishes to become a good writer should endeavor, before he allows himself to attempt more showy qualities, be direct, simple, brief, vigorous and lucid. He's saying that the writer, before trying to give any other kind of qualities, the basic qualities that he should focus on while writing is being direct, being simple, keeping it brief, keeping it vigorous and lucid. These are the things or qualities that you should imbibe when you are going to draft legal documents. According to him, there are 5 rules. The first rule says, prefer familiar words to far-fetched words. As far as possible, use the words which are used in common language rather than the meanings of which are not understood by the layman or general people. Familiar words are readily understood by people. Let's take an example. If I say, embargo, how many of us know the meaning of the word embargo? If I say that there is an embargo on travel, how many of us will be able to understand this particular sentence? Right? Because the word embargo is not used in common language by the people. On the other hand, instead of using the word embargo, I can use there is a ban on travel or there is a restriction on travel. These are the words which are familiar. Embargo is a far-fetched word. So they are saying use familiar words rather than far-fetched words whose meaning are not understood by the regular people or a layman. So he says that use familiar words when compared to far-fetched words. Second is, he's saying prefer concrete word to abstract. What are they saying? Concrete words make the meaning more clear and precise. He's saying use the concrete words rather than abstract words. Like if I say, for example, it goes without saying. This is a statement I'm making. It goes without saying that this is the situation. Instead of using a long sentence which is abstract, I can say that it is implied. It is implied without, so it is more concrete. The first sentence is abstract. The word implied can be used instead of me saying it goes without saying. Instead of saying it goes without saying, I can say it is implied for this particular purpose, right? So you should use concrete words rather than abstract words. Next, prefer single word to circumlocution. That a single word gives direct meaning. Avoid using adverbs and adjectives. Where you can communicate a sentence by using a single word. Why do you want to use a longer sentence? For example, if I want to say, right at this point in time, Instead of telling such a big sentence, I can say now one word can be used for describing the same thing. So in that case, they say wherever possible, you should keep your legal documents concise. That is the general principle we saw. To keep it concise, you should use short sentences. Where possible, in single word, if you can communicate the sentence, use single words rather than using a long sentence. Prefer short words to longer words. Prefer short words to longer words. What does that mean? What do we say by that? It says, let's take an example. Example is, if I say from now on, it is long. I can condense that into one short word by saying henceforth. Henceforth, this is going to happen. From now, this is going to happen, or henceforth, this is going to happen. So that is what the meaning is the same. All examples that I gave you, whether I'm using the first sentence or the second sentence or second word, the meaning is the same. It is just that the terminology and the language that we are going to use for the legal documentation work, that should be focused on. And these are the rules that have been given under 5 rules of drafting. Next one is use Saxon words rather than Roman words. Roman, in India, we only use the Roman numbers. These are Roman numbers. We don't use the Roman language. We use basic Saxon language, right? Whatever we have used currently, the PPT, it is in Saxon language. So you should use the language and not the Roman language. So these are the 5 basic principles of basic rules of drafting. If I have to summarize it, you can remember it. F2F, prefer familiar words rather than far-fetched words. C2A, prefer conflict words rather than abstract words. 3S, single, short and Saxon words, single word rather than circumlocution, short word rather than long word, and Saxon words rather than Roman numbers. So by this one thing, you can answer the entire question on what are the 5 rules of drafting, and this is one of the questions that is constantly time and again asked by the institute in your final exam about what are the 5 rules of drafting given by Mr. Fowler. Next, going to the second. So we said first we saw the general principles. After general principles, we saw certain additional rules that have to be followed. In additional rules, the first point is the 5 rules of drafting given by Mr. Fowler. Now we are going to go to the second additional rule, which talks about how should you do the process of drafting. First and foremost is you should prepare a sketch. You should prepare a sketch in your mind about how I'm going to structure my document. Before starting the process of verbal writing, we have to do the thinking work. Like I told you, in thinking, you should give a proper structure to your document. What after what, how I'm going to create the content of this particular document. For example, if I ask you to write a question on characteristics of a company for 5 marks, before writing the answer in your answer paper, you will think in your mind as to how I'm going to structure this particular answer. You will think that since it is for a 5-mark question, let me write the introduction. After giving the introduction, I am going to write the characteristics, and after the characteristics, I am going to give a conclusion. This is how you have created the basic structure for your particular document, that is answer on characteristics of a company. Once this basic structure is over, we are going to go to the next step, that is creating. Okay, before going to the next step, let us identify why it is important for us to create this particular structure. If you do not have the clarity right at the beginning about the structure of your document at all over, there is only going to be confusion. There is going to be chaos about the entire layout of your particular legal document. So it is very important that you should conceive the whole design right at the beginning to avoid any kind of confusion with respect to your document or the clauses that you have to include in your document. Next, after creating a sketch, what you should do? That same point I'm saying, what is the outcome? If the rule of creating a sketch is not followed, there is only going to be confusion. The document is going to be unclear, which is also going to be reflected in the final document. So right at the beginning, your intention and the structure or the layout of your answer or your legal document should be clear. Only then there will be a final good legally drafted document. After you have done the basic sketch work, we are going to improvise it. We are going to make additions to it. That is nothing but we are going to go one step ahead and make a skeleton draft. What is the skeleton draft? After we have generated the basic scheme or the sketch of the document, we should now briefly add matters or points to be included in that particular document. At this stage, the draft will be termed as the skeleton draft. For example, if we take the same question about the characteristics of a particular company. In the previous step, in the sketch stage, we wrote that we are going to write the introduction, we wrote that we are going to write the characteristics, and then we wrote that we are going to write the conclusion. This is the sketch draft. Now, after the sketch draft, we have to create a skeleton draft. What are we going to write in the skeleton draft? We are going to write that we are going to write introduction. Under introduction, we are going to write the meaning of a company. We are going to give the definition of a company. Then we are going to write characteristics. Under characteristics, there is perpetual succession, limited liability, separate ownership and management, separate person, artificial person created by law, common seal, right? You have a right to sue and be sued. These are all characteristics which you have to include in the draft. And after that, we are going to give a conclusion about what are the benefits of these characteristics of a company form of organization. So, from a basic document, I have gone to a next step of creating a skeleton draft. So, this is the first structure that is required to create an overall structure of what all I should include. Once I have decided how it should be structured, what should I add, what content should be added, that is required to be added. Once the skeleton draft is ready, we are going to then go and do the elaboration work. Nothing but each one of those points are then required to be explained. That is the self-appraisal. Right? We have to elaborate what we have already included, and whatever points have been included, time and again we should read it to see whether the language is correct, the grammatical sentence is correct, that the spellings are correct, and whatever has been included has been rightly written. So, that is self-appraisal, where we are going to elaborate and then also check whether what has been written is correct or not. Now, after you have done the skeleton draft and the self-appraisal, you should be able to satisfy yourself. The person who has drafted the legal document, he should satisfy that all the available facts, what are there, are correct and it has been reflected in the document. All the applicable facts of the case are there, laws of the case are mentioned, logical representation of the facts has been done using the appropriate language. The language that is being used can be understood by even a layman. You are avoided any kind of repetition. Avoid repeating the same sentence in your documents. Conceivable misrepresentations are not included. Eliminate any kind of ambiguity or confusion that is there with respect to the facts, and adhere to the rules of drafting, the 5 rules that we have studied previously, whether those rules are followed or not. So, once you have done the skeleton work and the self-appraisal work, then you should checklist whether this is correct, this is correct, this is correct. If everything is correct, that means your document is ready to be a final document that can be a full-proof document. But before finalizing it, before giving the final structure or approving the document, you should give special attention to certain documents. You have to take certain extra care while drafting certain documents, because additional provisions of law will become applicable, and for that you should take whatever necessary actions are there, you should comply with those. Next, special attention to be given to certain documents. For example, certain permissions are required. Okay, if you are going to start, let's say, a non-banking financial company, you need the permission of Reserve Bank of India for certain case. So, whenever the documentation is there, for the documentation, they are going to see whether the permission of RBI is obtained or not, or it is pending approval. So, all those special attention to details should be given when special or exceptional situations arise. Lastly, you should take expert's opinion. If you are not an expert in a particular field, you have done the basic legal drafting work, there is no problem in getting it vetted. Vetted means getting it verified by a person who is experienced. You are a fresher. You can do the documentation work and give it to your senior for review. Nothing but that is the same thing that you are going to do here, that if you have drafted a legal document and if you think that there is a scope for improvement, or you think there is a necessity that this document should be reviewed, you can definitely ask an expert's opinion about are there any changes that are required to be made in the document that you have drafted. So if the draft document has been prepared for the first time by a fresher and it has to be used multiple times again. So generally what happens in corporates, you have one employee contract. Whenever new employee is joining, that contract is going to be the same. We are only going to change the names and the remuneration clause, because every employee is going to get different salary. So apart from that, the structure of the employee contract is going to be the same. So when you know that the same contract, same document is going to be used multiple times, time and again, the same format is going to be used, that is called as the standard contract. If that is going to be a standard contract or a standard agreement, it is better that we get it vetted from a person who is an expert, who can give you suitable modifications depending upon what the requirements of each case, and you can get it vetted by an expert and ensure it is legally fit to be actually used in practice. So this is the entire process of drafting, right from conceiving the idea of drafting, the purpose of drafting, law, facts, putting into writing, using the principles of drafting, and then creating the basic sketch draft, creating the skeleton draft, doing the self-appraisal, getting it vetted, and then finally finalizing the document. So this is the entire process of drafting. What is it? First, we have to create the sketch. After the sketch, we have to create the skeleton draft. Once we create the skeleton draft, we have to do the self-appraisal. That is nothing but we only have to check whether grammatical mistakes, spelling mistakes, or anything kind of confusion is there. Once self-appraisal has been done, you can finalize it, keeping into mind certain extra situations, extra points that you have to keep in mind. And finally, once you think it is a final document from your side, there is no problem in getting it vetted from an expert. And once he is also approving it, if he suggests suggestions, you can make changes. If not, you can just go ahead and finalize the document, which can then be utilized for the objective for which it has been created. So this is the entire process of creating a legal document, keeping in mind the various principles and the rules that we have studied. So with this, let's just end the session for today on drafting, pleading and appearances, specifically lesson number 2 on the general principles of drafting. If you want more assignments, so what we have started a new batch which is going to be giving preparations for the June 24 exams. So if you are going to appear and if you're interested, you can get in touch with us. At Ekcel, we are going to focus on not only giving you the theoretical knowledge or explanation of what is there as a subject, but we are going to give you a lot of practical exposure on constant basis. I am going to give you a lot of assignments of drafting, doing the necessary valuation of that and giving you feedbacks of how you can improve your drafting skills. Because ultimately in the make exam, they are going to ask you to draft. So merely studying the provisions is not efficient. You should have the necessary practice also, and we will give you the necessary required skills that you want to pass these kind of exams. So if you're interested, you can definitely get in touch with us for these classes. Have a nice day and prepare well for your exams.